Okay, so I'm going to go ahead and stop sharing my screen now. There's a few people in the waiting rooms that I need to let in. So Camila, if you could just give us a minute, I will do that. But I just want to emphasize, I guess I should wait until I have everyone admitted to do that. So give me 1 second here. Okay. So thanks everyone for joining us. Well, today you're going to be listening to Camila Motta, but I am Angela Princewell, and I'm the founding lawyer here at AP Lawyers. And I'm very excited to also listen to Camila's talk because even being a lawyer and and just kind of practicing the philosophy she's going to be talking to you about to you today, we can always learn. So I'm always excited. And Camila has a wealth of knowledge when it comes to dealing with wills and estate planning matters. She's a family law lawyer here at AP Lawyers, and she also recognizes that, you know, while we plan for people in family situations, when they're getting married, if there's a separation or divorce, your planning is really not complete if we don't talk about the ultimate end, right? And I know it's a bit morbid for some people, but I appreciate the number of people we have logged in here. It just shows the recognition for how important it is to have proper wills and have your estate planned. So you couldn't be hearing from anyone better than Camila. And fun fact, Camila is fluent in English and Portuguese. So if we have any Portuguese people joining us today, please know that if you're more comfortable kind of working with her in Portuguese, she got you covered. So Camila, with that, I will hand it over to you. And if we have any time at the end and we have a bunch of questions actually that we've already received. So I will kind of ask that first. For those that are live with us right now, I think there's a chat button at the bottom. So if you want to put in your questions there, I'll try to monitor it as we go along. And, you know, Kevin, if I need to interrupt you to kind of jump in on a question there, I will. But for the most part, I will stay away from doing that so that at the very end, we can take all the questions that arise. Okay.
Okay. Thank you, Angela. So as a family law lawyer, will is actually something very important, especially for the undesired results of separation. What can happen with your estate if you die while you're separated but not divorced yet? So would you like me to go ahead, Angela, and answer the questions we had before?
Okay, so I want to make sure I don't throw you off, but let's see. So we had someone wondering why they would need a will in Canada and what if they don't have one. So I guess this is a lot of questions. So the person is also asking what happens if you die without a will or without making one. So to paraphrase, this question just really wants to know, living in Canada, is it really important that they have a will, and really what happens if they don't have one?
Okay, so it's very important to have a will, especially if you have small children, because that's the biggest concern for people who have children under the age of 18 because if both parents die in an accident, they need to appoint someone to become their guardian. And in the will, you can make a temporary appointment for 90 days after your death, which will allow the person you are appointing to apply to court and have permanent custody of the child. If you don't do that and there is no one, the court needs to assess whoever is going to get this guardianship, even the temporary one. And what happens immediately after your death is that your child goes to foster care. So that is like traumatic enough to lose both your parents at the same time, and then you end up with a family you've never seen before. Even if it's temporary, it's something, of course, we would like to avoid. So one of the biggest concerns is to ensure you're planning for your child, not just financially, but who's going to take care of them. And just to make it very clear, it's the court that appoints the permanent person to have custody of the child. The appointment we do in the will is just a temporary appointment for them to have the time to apply to court. And while the application, and AP lawyers can help you with that too. And while the application is going on, the person then this deadline is extended, and they can care for the child until the custody is decided. Okay. So what happens if you die without a will about your assets? So first, if you are married, your spouse, if you only have a spouse that survives you, your spouse inherits everything. But the problem is they need to be appointed by the court. So that means that doesn't matter if you only have $10,000 left, or actually you don't have anything, you still need to deal with the CRA. And to deal with the CRA, someone needs to be appointed as your estate trustee. So, and to do that, they need to apply to court. This takes time, this takes money, this takes energy. When you have a will, it's simple enough, you can just go ahead. And only in a few situations you need to apply to court. I can't hear you, you're muted.
Oh, just to be clear on that point, you're saying if a person has a will, they don't need to apply to court for.
So then it depends on the institutions they are dealing with. So let's say they have real estate, because they are going to be dealing with the land registry office. That they require a formal document from the court. In that case, you do need to apply to the court. But let's say you are a joint owner of your house, and the other owner survives you. So you are not transferring. You don't need this document to change ownership of the property. If you only have like bank account, then you don't need to apply to court. When we are drafting the will, we actually do everything we can to avoid the need to go to court, because that means you'd have to pay taxes, it will take more time, and you have to pay for the court process itself. So we try to avoid that. Sometimes we cannot avoid, but we try. My son is having permanent visa. Please advise when it would start.
Yeah. No, that's for us here. Yeah.
Okay. So about the appointing guardianship for a child, ideally, yes, both parents should appoint the same person, because you're only going to be looking at that appointment if both parents die together. And if they die together and each of them appoint a different person, then the court doesn't know who should take care of the child. And in doubt, they will send the child to foster care. So yes, you should always decide who is going to be appointed and appoint the same person.
As a family law lawyer, Camila, can you weigh in on whether it matters? So in a sole custody situation, is it okay for just the parent with sole custody to appoint the guardian, or you would still advise that they both agree?
Yes, because what you're transferring is your right of custody over that child. So if you don't have the right, you can appoint, but it won't really matter. So in our document, my draft says, if I have the right to appoint a guardian, meaning if I have custody of this child, then this is the person I'm appointing. So if you don't have custody of the child at all, then you won't really get to appoint someone else. Okay.
So so there's implications for property in terms of how much in terms of tax planning and things like that. There's obviously, you also mentioned the implication for the younger children. Is there anything else we should be aware of?
Yes. So if you don't have a will, you're going to die intestate. So you cannot really choose who is going to inherit. Who chooses is the legislation of the province. And here in Ontario, that means if you have a surviving spouse and no kids, your spouse inherits everything. If you have a spouse and kids, your spouse inherits the first 200,000, and then they share with the children whatever is left. Okay. One big problem is if you're separated and if you live in a common law relationship, because a common law partner will not inherit anything if you don't have a will. That can be a big problem. So say, for example, you're married, you're legally married, but separated and living with someone else, your common law partner will not inherit anything, and your spouse will be able to inherit. So the only exception is that if your common law partner can prove that they depend on you financially, then they will have a dependent claim, but not a spouse claim against your estate. Okay.
That's really interesting. So in the scenario with the common law partner and the people separated, so pretty much no one, I can just imagine that creating chaos with no one having sort of actual rights there. So I guess for our clients that are sort of separated and maybe going into new relationships, it might be a good idea to get their will right away, because some people want to wait until they get a divorce. Is that even necessary, or just?
They shouldn't wait at all, especially in that situation. If you don't want them to inherit anything, and usually if you're separating, you want it to go straight to your children or your new partner or maybe your parents, then you should, actually it's kind of urgent for you to prepare a will. And if you do have a will, and that you are appointing your former spouse, then of course you also need to change your will. And when you get divorced and you have a will, then we consider your spouse to have predeceased you, but that's only after the divorce.
Okay.
So they're not going to inherit anything, but that's only after the divorce.
Okay.
Okay. So there are some questions. If you assign an individual in your will as a recipient, of all of your assets, can this document be rebuted by a dependent? Yes. So that's a dependent claim. So they can challenge the will if you don't provide, if there is someone that is financially dependent on you and you don't provide for them on your will, they can bring a dependent claim against your estate, and then they can challenge the will completely, or they can just say, I want my share, I need my share because I was dependent on that person. So yes, if someone is dependent on you, it's better for you to provide for them in your document. I have a will in place, but I do not have a separation agreement signed by my husband. We've been separated for 2 years now. Well, that's kind of two.
Yeah, so he's completely ignoring all the correspondence. The matrimonial is only in my name, but I understand that isn't a common law partner the first in line. Okay, so I think you kind of answered this question. Okay. Is there anybody that sort of has a first in line to be the estate trustee? Because
no, so it's not a first in line. Your spouse, your legal spouse, so the person you're married to, and your common law partner, they can be your estate trustee. That does not mean that your common law partner will inherit anything. So they can have the work, but they will not have the prize.
Can you maybe explain the difference between the trustee and the beneficiaries under the will, just in case there's that confusion there?
Okay, so there are a few people we appoint. So first, the executor. So the person who is actually responsible for the will, and that's going to manage your estate. And then there is the person who is your trustee, which is usually the same person, but you can name a specific trustee to deal with. So for example, the trust you leave for your kids. If they're minor, you prepare a trust, and then you can appoint a different person to be their trustee. Or if you're creating a specific trust, you can have a different trustee to deal with part of your assets. Okay. The other thing you appoint, the beneficiaries are the person who are actually going to inherit. So they get your car, they get your house, they get your I don't know, they get your money in the bank, they get your RSP. Well, RSP is going to be your spouse, or it goes to your estate. But these are the beneficiaries.
Okay. So this person, oh, sorry, go ahead.
So the common law partner is not, so there is not a preference when the court needs to appoint who is going to be your state trustee, your executor. So they can look, any beneficiary can apply. So anyone who has an interest in your estate can apply to be your executor, your married spouse or your common law partner. But that does not mean they will inherit.
And there's no right. There's no right.
There's no right. And there is not like, if you have a spouse, then your son cannot do it. No, the court will use their discretion to decide who is going to be your executor.
Okay. So Kathy was wondering if the will, if she has a will in place, is it still a valid will, even though she doesn't have a separation agreement signed by her husband?
Is it still a valid will? And he will, like, he's going to be the executor, like it's a valid will and it will be followed. So that's crucial, that if you are in this situation that you are separated, not yet divorced, and not remarried. Well, if you're not divorced, you cannot remarry. So it's not here in Ontario. But that's when you're kind of like in a limbo that you do need to deal with it, because then you can have very undesired results there.
Okay. And Tara's wondering, is a will that's created before marriage still valid? I guess so. After you get married, is the will you created before you
get married? So marriage does, it's not, the will is not valid after marriage. It cancels your will. You can draft a will in contemplation of marriage. So if in your drafting you say, I'm going to get married and I'm preparing this will in advance to my marriage, then that's going to be still valid. But if you prepared a will, I don't know, 5 years ago and you're getting married now, then your will be canceled after, will not be valid after your wedding day.
So it's important that everyone that gets married sort of, I guess, updates their will, so to speak.
Mm-hmm.
Okay. And
okay,
so we had a previous question on what are the decisions I need to make when preparing a will?
Yeah, so you need to decide.
As well. So this person wants to know regarding wills and powers of attorneys. And just before, I mean, this is a specific question, so I don't know if we all necessarily understand what a power of attorney is. What is a power of attorney?
So a will is the document that is valid after you die.
Okay.
Powers of attorney are documents that are valid before you die.
Okay.
So up to the point of your death, it's a power of attorney. And then you can have two. You can have your power of attorney for property, who is the person who can do anything on your behalf financially. Okay. They can also be, depending on the draft, they can also be your litigation guardian, meaning that they can represent you before court. They can do anything. They can buy real estate, they can sell real estate, they can invest money, they can withdraw. Depending on what you're saying, they can even donate your money. So of course, it has to be someone you completely trust. Okay. And we can draft in two ways. One, that you need to be assessed by a doctor that will say you are not competent right now, you don't have the capacity to deal with your assets. So someone else needs to do it on your behalf. Or it can be valid as soon as you sign. I can prepare both, but I always advise my clients to prepare the other option, which is valid right after signature. And I prefer that option because many banks and many institutions, they don't want to deal with the assessment. They feel uneasy about, like, is this person, is this really valid? Like, did a doctor really assess this person? Because they believe that what if this person has the expectation that this document is not valid, and someone got this document, like from this assessment from a doctor, and I'm not sure if it's real, and they want to manage the bank account, for example. Okay. So most institutions, they prefer to have a power of attorney for property that will be valid as soon as it's signed. So the grantor, the person who is giving this power to someone else, knows fully that they will be able to do all that is written there on their behalf. Okay. The other option is the power of attorney for personal care. which is when you're appointing someone to take healthcare decisions for you. So that person, and then for that, we need an assessment. So a doctor will say you cannot make these decisions for yourself anymore. Someone else needs to decide for you. And then you can put your last wishes there. So what you want right now. So you want to stay home for as long as possible, or do you want to go to a retirement home? And if you're going to a retirement home, what you want to be considered? Like, do you need, is having social events important to you? Is it being a specific city important to you? Because like it's very expensive. So sometimes like a family member can send you to, I don't know, 2 hours away, and then your family doesn't visit you. So you can put in your document that you want to be within a certain area. You also decide on organ donations, treatments you'd like to receive. So any of these wishes you can put there. About how to deal with your body after you die, then that's on your will. If you want to be cremated, like any funeral arrangements, then you can put some suggestions on your will, but it's not binding.
Okay, so these goals, so in terms of how you want to be cared for personally, do these go in the power of attorney document or in the will document?
The power of attorney for personal care.
Okay, okay.
And that in the United States, the idea of a living will is very common, and people here sometimes get confused. What is a living will? In Ontario, we don't really have this document called living will, but it's basically when we see it's basically a personal power of attorney for personal care that is very detailed. So you put all your instructions there saying everything you want. I want to receive morphine. I don't want to receive morphine. I want oxygen. I want artificial respiration, like anything, you can put it there.
Oh, that's interesting to know for sure. Okay, I think I got carried away there with the power of attorney. So did we answer that question about what decisions do I need to make when preparing a will now?
Yeah, so the executor and trustee, which is usually the same person. It has to be, of course, someone who you trust, but also you need to consider if it's someone that can actually do the job. It's not an easy job. They can hire someone to help them, but of course you need to be someone that is organized, that is like it's a good age to be able to do everything they have to do, right? They have to live in Ontario. They cannot not live in Ontario. The other thing you need, and we should also appoint always 2 people. So the primary, usually for a couple with children, for example, the wife is going to appoint the husband is going to appoint the wife, and then there is an alternate that they need to appoint, because in case they are involved in an accident together, someone else needs to step in, and then it could be an adult child, a close friend, or and it's very common for my clients who are immigrants here, they don't have family here. So there are trust companies that can do the job for you.
Oh, okay. Yeah. I mean, can you tell us a little bit about trust companies?
Yeah, so the trust companies, usually they only deal with millionaires, but I was able to find one company, and I'm sure maybe there are more, that they can do it even for small states. Okay. They don't charge anything for you to appoint them. They can actually hold your original will for you. Mm-hmm. And they will only charge if they have to step in and act. So if in the future, the person you appoint as the first executor is not available, or they can refuse, no one can be forced to be your executor. Yeah. Then they will step in and then they will charge.
Wow, that's very interesting to know for sure, that there's options and you're not stuck begging everyone in your social circle to
no.
be executive. Yes. So that's great. Okay, so we have some questions here. Oh, I see Kathy didn't hear our response, but we'll see if we have time at the end to kind of go over her question again, because I know we did go over that in detail. So Tara is wondering, does the spouse trump beneficiary? So if your son is listed as beneficiary and you're married, will that go to your spouse or son? So things like, I think she's specifically talking about RSPs, insurance and TFSAs? Do they go to your, can they go to your child even though you have a spouse, I
In
guess?
your will, you can distribute your estate as you wish.
Okay.
So there is just that exception that if someone is dependent on you and you don't provide for them on your will, then they can challenge your will, and then they may get a share, but then that's a court process. So, but in your will, you can give everything to your children and don't leave nothing to your spouse, for example. Or you can leave 70% to your spouse and just 30% to your son. It's up to you what you do in your will.
And if he's not, if he's doesn't qualify as a dependent under the act, then there's really is no basis for a court challenge at the end of the day.
No.
Okay, so
only if they try to, they can claim discrimination, that he was excluded because, I don't know, he decided to be an actor. And then because of that, their parents don't like it, and they left everything to all the other kids, but not to him. So they may claim discrimination, and then that's a whole different
issue.
Beast there.
Okay. Now and I know this is not part of Tara's question, but this is just mine, and because I get asked this often. So with RSPs, insurance, and TFSAs, if I have a designated person, so if I make somebody my beneficiary to my RSPs and things like that, is that sufficient without a will, or would my wishes be respected in that regard? Or if I die, does it all have to come back to my estate?
Yes, no, it doesn't go to your estate if the person is alive and if they can receive it. So it will go to them. And when we got the will, we make appointments again just to make sure, because it's your last known appointment. So you put it here, and a good thing when you're preparing a will, you actually see all your assets. And that's why we have such a detailed intake form. I know it's super annoying to fill all that information out, and usually like it takes the clients a couple weeks at least to complete, but it's because we need to look at it and we need to see what is going in your estate. Because you may look on your bank or you look around and if you, okay, so I think I'm worth about $1 million, but not, so my kid, I'm leaving like half to my spouse, half to my child will have $500,000. That may not be the case, because you need to see what is actually going to form your estate. So if you are a joint owner, the survivor owner is going to inherit, to receive everything as a right of survivorship. So that does not go to your estate. So, and then if you have a TFSA and you have a beneficiary there, that's not going to your estate. If you have the RSP and you have a spouse appointed there, that it's not going to your estate. So it's not uncommon to have very little left on your estate. So that's why it's really important for you. That's why we call estate planning, because we need to look at everything and then decide and really analyze who is getting what.
Okay, so I see my kid is asking, in regards to the trustee/executor, what if they live in Ontario at the time the will is created, but live out of the province or outside of Canada at the time of your death?
So that can be a problem. That's why, and that's one of the moments you need to review your will, because it's not like the courts can use their discretion to appoint someone that does not live in Ontario, but I do not recommend my clients to trust that. So if you appointed someone and you do not have an alternate person, and the first person does, like if you don't have anyone appointed that lives in Ontario, that's a moment for you to review your will, and then you can actually prepare a codicil. So you don't need to redraft your whole will. It's just a codicil, which is like a document that will just change, like minor changes like this. You can say paragraph 1, this is going to be the new wording, and then you are appointing a new person. You attach it to your will. It's all the same formalities to sign a codicil, and then you change. But I highly recommend you to do something about it when you know the person is not living in Ontario anymore.
So this is why it's important, I guess, to have that alternate for sure, so that
and you can have more than one alternate. You can have 2, 3. You can have as many as you want. And actually, like the person who doesn't live in Ontario anymore, they can actually appoint someone else. Like whoever is left as your executor, depending on the drafter of your will, they can appoint someone else. So you don't need to go to court.
Okay, that's
Okay.
very helpful. And then there's another question. If the spouse at the time of death did not leave sufficient money and splits the funds with the children, do I have to bring a dependent claim, or do I automatically get the preferential share as their spouse? So did this person, I'm not sure if this person died with or without a will, so, but she's saying there was not enough funds and split the funds with the children. So I'm guessing there was a will without a lot of money, but whatever the money was went to the
I
kids.
can respond it both ways. If it's intestate, then the first 200,000 goes to the spouse. If
Okay.
you have 50,000, all the 50,000 goes to the spouse, and nothing is left for the kids.
Okay.
You only share what's over this preferential share. If it's in a will, then again, you can distribute it as you wish. And then if the spouse feels they were not provided for in their will, then it depends financially on the deceased, then they can go and bring the dependent claim. But then it's not automatic when there is a will, because then you're following, then the will becomes the law. So you're following whatever is in the will.
Okay. Okay, so let me go back to my earlier questions. Okay, so we did talk about sort of the decisions to make regarding the will. I think I see a question here about if a beneficiary owes you money, if a beneficiary in your will owes you money, would their debts be forgiven when you die, or is it discounted from their share?
Yeah, so that's very common when you have like 2-3 children. And let's say that during your life, you helped child A to buy a house. So
Okay.
you give them $100,000 for the down payment of a home. Do you want that to be discounted from their share when they inherit?
Mhm.
Or this is going to be forgiven, like this was a real gift, and all your three children are going to share equally what they inherit in the end, what you have on your estate. So that's usually like just to avoid family fights, because people can get very agitated when they're fighting for money. So if you have, I don't know, 2 siblings, like you may feel like, oh, why did daddy give the down payment for their house when I had to work so hard for mine? And now he's going to get double because he's getting the same share I got, but he got this money before. So that's something we should consider in a will. One other thing that you need to appoint is, of course, the beneficiaries, everybody who is going to get what you inherit. And then you need to think of 3 situations. One, if your spouse is alive, who is going to inherit? Is it just your spouse, or what about your kids? If you don't have a spouse anymore and you only have children, who is going to inherit? And if you don't have spouse or children, we say it's a family disaster. If everybody dies together in a plane crash, what happens? Who inherits it? Yeah. Okay, and the other thing you need to appoint, of course, is a specific trustee for a fund. So if you want someone to manage the funds for your child while until they reach a certain age, and you don't want that person to be the same as your executor, you can appoint another person. Usually it's the same person as the guardianship, like you can appoint the person who's going to have the custody of her child to be the trustee of their fund. And you also need to appoint the guardian.
And that's a lot of things to consider. I guess that's sort of where retaining a lawyer helps. And that actually is, interestingly, the next question. Because someone said, why do I need to hire a lawyer to make a will? I've been told that I can make a will on my own. So what do you have to say to that person who was wondering if they could just do their will on their own?
Yeah, so it is a lot to consider when you're creating, when you're drafting a will. You need to consider the laws, like who may have a claim against your estate. who can be the trustee, who can be the executor, what's going to happen with your house, depending on how you hold title of the house, who can get the RSP, who can get the RESP of your kids. It's so much information like that you can draft. Like there is no requirement that a lawyer have to draft your will. And you can see online, you can buy wills for $200. But these $200 can cost you, or it can cost your estate and your beneficiaries a lot of money if it ends up in courts because someone is challenging the validity of it. The other thing is there is a lot of formality. It's a very formal document. I would say it's the most formal document ever because you need to have the actual paper that the person signed. You cannot have a true copy. You cannot have a scanned copy, obviously. You cannot have, like, it has to be signed with everybody together. So there is a lot of formalities that you don't want to miss and run the risk of not having a valid will.
Yeah, I think that's what gets to me personally the most as well. For every other sort of agreement you do, even with separation agreements, court orders, things like that, if you're alive and you notice a mistake, and you can always go back and apply to get the mistake changed. You can bring a motion to change. There's just options. But with a will, if you care enough about your family and the people that you're leaving behind to actually make a will, then you should care enough about everyone to do a will, then you want to make sure it's done right, because you're not there to answer any questions or clear any ambiguities, and the cost for that can be significant.
Yeah, and if you think about it, you're not going to be preparing a will like every year, right? It's just like, it's not a once in a lifetime event. You may have to have like a couple wills throughout your life, but it's like one every, not even 5 years. It depends on how many changes you have. And you may only need a codicil when there is a change. Because also when we're drafting a will, we try not to be specific. We try to be as general as possible. So for example, for a new couple, I'm already saying, even if they don't have children, I'm already saying that if they do have children, and as many children as they have, this is how we're going to deal with the estate. So they can have 1, 2, 3 children, and they don't need to change the will.
Okay.
Or they can have 5 bank accounts now and have only 1 bank account when they die, or the opposite. They may have 1 now and 5 when they die, and they don't need to change the will. They can have 1 house now and 5 when they die, and it's not going to, you really don't need to change unless you're dealing with things specifically.
Okay.
One other thing that I do in my drafting that helps making it general is that I add a clause for a memorandum. So that means you are asking your executor and trustee to look at any memos you leave attached to your will that is disposing of some smaller assets you have. So let's say you have a ring you want to leave to a grandchild, but then you change your mind, you want to leave to the other grandchild. Then it's just like a paper you do, you write, you sign, you date, and you attach to the will. It's not binding, meaning that it will not stand in court. Like you cannot, someone cannot come and like ensure it's going to be followed, but you are appointing your trustee, and it's someone you trust. That's why it's called trustee. And you are asking them to please consider the letter you leave attached. So these are ways we have to deal with a will, and so you don't have to be paying me to prepare your will every few years. So the expectation is for you to only have to draft maybe, I guess, when you marry, divorce, but then that's not on me, that's on you guys.
So there's a question here that says, if I get an inheritance from my parent, how is that treated in a separation? So, I mean, this is a family law question. Do you want to take that, or do you want me to answer that?
You can go ahead.
Okay. Well, now we're entering the realm of my understanding. Well, an inheritance under Ontario family law is excluded property. So if you get an inheritance from your parents and you separate, yes, you can exclude that. there's obviously some caveats. For example, if we can't trace that the inheritance. So a common issue that I've seen on some of my files are you get an inheritance and you put that money into a joint account. Well, money that is in a joint account is going to be presumed to be joint, and the right of survivorship, and Camila has mentioned that a number of times, the right of survivorship applies to that. It's assumed that under the law that it's owned by both of you. So even though your inheritance is entitled to be, you're entitled to exclude the amount from when calculating how it's divided. So in the simplest of terms, if you have an inheritance, it's yours to keep. You don't share it with the other spouse on a separation, but it needs to be traceable. So, and you need to be very careful when you put it either in joint names, or when you put it, you know, a joint account, for example, or change title and have it in joint names, then it could get a little bit tricky. It doesn't mean you've completely lost it. There's situations where we've been able to make arguments to ensure that we get that inheritance back for you. It just makes it a little bit more challenging. It may also be challenging for you to get that back if you've put your inheritance into a matrimonial home, right? And how many times does that happen? As Camila even said earlier, sometimes when parents in their lifetimes would give a portion of the inheritance to a child who ends up buying, you know, as a down payment for a home and things like that. Well, you may not be able to get that back because it's in a matrimonial home. So short story is, yes, you're entitled to keep your inheritance all to yourself. That's the general rule, but there's situations where you may be forced to share it with a partner.
There's one more detail,
yes.
And that's where the will comes in. Because the provincial legislation tells you that you don't have to share the inheritance, but it does not tell you that you does not have to share income from the inheritance. So if you put the money in the bank and it makes you $10,000 a year, that $10,000 are shared unless in the will you put that anything that comes from the inheritance is not to be shared. And of course, I have it in our draft, and so that's the standard for us. Like here, we prepare in a way that the income is not going to be shared.
That's a very important detail. Thanks for adding that, Camila. So I feel like you may have answered this question already, but this person's asking, when is the ideal time to make a will?
The ideal time, well, if you are preparing your taxes every year, you should have a will. Because once you die, your estate needs to resolve their account with the CRA. And if you don't have a will, then you need that court process that I talked about in the beginning. So a will, even if you don't have much, even if you have nothing, you are reporting your taxes, you need to deal with that. For sure, when you have a child, because of the thing about the guardianship, when you get married, when you're living in a common law relationship, even more important than than when you get married, if you're living in a common law relationship, if you separate and before you were divorced, that's a very important moment. And of course, if you have a will and someone that is named in your will appointed somehow and they die, you should at least review to see if the results are still what you want, or if you need to change something.
Okay.
Yes, you have to pay probate tax. They're asking if is inherited exposed to probate tax. It depends. So you pay probate tax if it goes to court. If you don't need the court process to distribute your assets, then you don't need to pay probate tax there. But if you do need the document, and that's why if you don't have a will, you need the court process, so you will for sure pay probate tax on all your estate. The tax is not like a lot, but it depends on how big your estate is. It's about 1.5%, but it's not that straightforward, but it's close to that.
So can proper estate planning and proper drafting of a will kind of help you I don't want to sound like we're avoiding the taxes here, but kind of help you manage and pay the maximum the minimum rather that you're required to under the law.
Yeah, and it's not we're not doing anything that is against the rules.
Okay.
We're doing everything by the book, by the rules, but it's simply like there is an option that you're not required to go and apply for probate. So, and then in that case, you're going to save the taxes. And we also sometimes we prepare 2 wills. So one will is the first will is to be probated. The second will is not probated. So usually when you have a business, all your business, how you're going to manage your business after you die, then that goes to the second one. Because if you're dealing with your business in your one will, then you're going to pay probate tax on your business value. And then even just to assess the value of the business can be a headache, right? So sometimes I don't use, I can do it, but sometimes it is appropriate to have 2 wills because then the second one doesn't go to probate.
Okay.
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 Did you get it or no?
I'm trying. So that sounds to me, I just want to be sure I understand. So that sounds to me like you can have 2 wills.
Yes.
Oh, okay.
So what we do is let's say a person has many assets and they have assets A, B, and C that will need a probate. Mm-hmm. So they have to apply to court even if they have a will. But then they have assets D, E, F, G, H, I that don't need a probate. Okay. So you separate and you put all this in the second will, and then you only pay probate on the first one, and you don't pay on the second one. And that's not wrong. The legislation allows us to do that. So, and that's why they want the probate for those institutions that really require the document. So that's how they're, I guess, protecting the public interest, right? And also someone is asking me in private here about the consultation, how the process happens here. So you can book a consultation. It's a 20-minute consultations, questions and answers. It's $90, but that is applied towards the final fee if you hire us to prepare your documents. Okay, and you can book that online, or you can book that with Shariah here when you call the office. And I'm actually giving a discount to everyone who is watching today. We can give a 15% discount until the end of February.
Okay, so what do they need to say? How do they let Shariah know that they're entitled to this discount?
just tell that you watched the webinar and that I told the webinar that we have this discount for 15%.
Until the end of February.
Until end of February.
Okay. Okay, so so somebody had asked earlier if the will is a once in a lifetime event, but I think you've kind of answered that already. Mm-hmm. Yeah, so you did say it's not something you change all the time, if I'm paraphrasing right, but there's major events or timelines in your life when you need to change your will. And I think you mentioned maybe no more than twice, maybe 2-3 times that you need to do a will over the course of.
Yeah, it depends on how many times you are separating, divorcing, and people around you are dying or moving, but generally you shouldn't need a number of wills throughout in your lifetime.
Okay. And the last question was what documents, so this is someone that obviously has consulted with you and wants to go along, and I think I'm not sure if they did, but they're asking what documents they need. I'm imagining you would cover the documents required in a consultation, right?
Yeah, but generally, of course, we need the ID, because to open a file here at the office, the Law Society requires us to verify your ID, so we need a proper government issued ID. And then I need information from your assets. You don't need to show me evidence of your assets, but I need to have your information and also your life insurance policy numbers. Yeah, so the information you need, as much information you can give me so I can plan your estate properly.
Okay.
And also sometimes people, they're not really sure how they hold title of real estate property. And that's something we can do for you. It's It's very cheap to just get the document and see how you're holding title. But if you have that information, if you have the document, that's helpful too. If you were married, if you have a marriage contract, cohabitation agreement, or a separation agreement, that's also something I need to review, because I need to see how you're dealing with your state there. How
Okay,
you
yeah.
agree to deal with
That's a
your
very good point, because often when I draft separation agreements, there's certain terms that I include there saying the parties have to, you know, either draft wills to reflect this, or they have to inform their executors and things like that. So that's a very good point for sure, because yeah, you don't want to create chaos after you're gone. So I don't see any new questions here. Oh, thanks, Anissa. I see your comment. It's been very informative for me for sure. In as much as I'm a lawyer, and you know, I do know basic wills and estates law. It's important to talk to someone that practices it's actually their area of practice. And you can see that Camila knows this area inside and out. And she's, you know, available to have consults with you, and has even offered the 50% discount. So that's fantastic. If there's no other questions, I don't know, Camila, do you have any private questions? I think this is all.
No, I answered everything here.
Okay, awesome. So thanks everyone for tuning in. We're going to post this on our YouTube channel. So, and yeah, you're welcome to everyone who's thanking us. It was absolutely our pleasure. Thank you so much, Camila, for sharing your wealth of knowledge. And we look forward to seeing you guys at our next meeting and / webinar. Take care, guys. Bye.
Bye.